YouTube, it's Tone back again with another one for you. Now, so this one today is a continuation of creditors and their bonds, right? And so as I read through, I'm gonna try to elaborate the best I can for you. That means to go a little further into detail. Elaborators go a little further into detail. So here we go. Let's just get into this shit. Here is an example of a typical court scenario when a man participates. Investigator from ABC agency or a municipal corporation has filed an information with a prosecuting attorney on the public side. Affidavits are not required. So, I mean, whoever goes in there and makes a statement just in general, it's going to come out in the form of an affidavit and they're going to have to sign it and shit like that too. So you want to be careful and make sure that you always get in the habit of filing a counter affidavit, because what they do a lot of the time is they won't tell you that the evidence that they have against you is only in the form of an affidavit, and that's going to stand as fact and truth in law after 30 days if you don't rebut their affidavit or accusation point for point. So when you go in there and you're just talking and arguing with them, they don't even hear you. All that they have is the paperwork that's in front of them. The court is paperwork. So if you don't bring your paperwork and you don't file an affidavit, all that they really have is the state's version of what happened, and whatever you say doesn't even matter because it's not in the form of an affidavit. Remember that court is paper. The paperwork is the court. So you got to have your shit in line. The informant is not required to sign an affidavit submitted to the attorney to commerce. A public action against the individual is being investigated. Affidavits were required in equity when someone wanted to file a claim in court and in admiralty, and the public affidavits are no longer required. They have been replaced with what is called an information. Okay, so if all they're doing is filing an information and you file an affidavit, then you fucking win. You know what I'm saying? Because whoever puts in the affidavit is going to fucking win. So fuck what they're talking about. Make sure you get your affidavit of truth in and shit like that too, along with your affidavit of commercial copyright, etc. And we're going to get into that in the next couple of slides. An affidavit is signed under oath. The statement made in an affidavit are the signer's bond. A bond, and it has to be backed by something, right? A bond is a promise to pay. So when you sign an affidavit under the penalty of perjury, your ass is on the line, and if you lose, I'm coming for that ass, right? The same way that they'll fucking do it to you. So his word is his bond. The affidavit formally bonded the case. Now that there are no affidavits, there are no bonds to bond the case. Now keep in mind that you can bond the case just as well. You can bond it with a piece of silver, a $20 silver piece, and then, I mean, you're probably going to win at that point because the case should be bonded. Somebody should fucking have their ass on the line. You put up the only real thing of value, which is the silver, and you can bond it with that. The prosecuting attorney has to decide whether or not to commence an action. The informant may have completed an administrative process, IRS, 90-day letter, 30-day letter, 10-day letter for the attorney on the basis of bringing forth the action. It may not have started an administrative process. Right? So this is, I mean, they're administrative scam artists. And the administrative process is fucking so powerful. This is why you need to understand what it is to serve these people properly and keep good records of all your of everything that you do, really. So these are things that you want to get in the habit of doing. So here, what do we got here? So 9 times out of 10, the administrative process is not needed because they are almost always sure you will agree without knowing it to represent the accused individual, the trust, by volunteering to act as its trustee or surety, right? The attorney is going to create a new trust to be the accused on the complaint or indictment. If you go into contempt, you are for defending and not taking responsibility for the new trust. You will either pay with the trust corpus or you will go to jail, and your credit exemption will be tapped during the time they are housing you, feeding you, and giving you medical treatment. The trust corpus might include the balance in a bank account, a title to real property, a car, or other public asset. The creator. The attorney is the creator of the accused trust. It might be all caps John Henry Doe. Notice that they never put your name on the complaint, indictment, or traffic ticket. Even if it is written in upper and lower case letters, it is still a fiction and a trust. We cannot mix public and private, because you have to understand that these people are all corporations, public entities. They cannot even fucking speak to you as a private living soul, private living man or woman. They're not fucking allowed to. So they're gonna try to trick you into the fucking nonsense and get you to entertain their bullshit. Trust name. The name of the trust is, all caps, John Henry Doe. In the body of the complaint, a reference may be made to John Henry Doe or John Doe, or upper lowercase John Doe. This is how the judgment can be multiplied, right? And they'll name you differently, and maybe in different parts of their fucking fake ass letters, making demands and shit like that, right? They'll have your name spelled differently in different things. Those are all going to be different bonds, right? So you have to fucking address each of those individually, right? Not at the same time, because you want to waste their fucking time just like they waste yours. And when you start filing your copyright and shit like that too, every time that you have to fucking send them anything, you're going to send them a fucking invoice just as well for whatever the fuck you think your time's worth, right? So this is how judgments can be multiplied. These might all be new trusts against the final judgment can be applied. And for which it is presumed you will volunteer to be the trustee, and through which you will be presumed to be the surety. The trust is expected to be the defendant, right? So the defendant is actually the trust, and we make the mistake when we go in there and we speak as if it is us, and it is not us. We are the authorized representative, right? And or the beneficiary. We are never in the fucking position of being the trustee or the surety for any of this fucking bullshit. You know, especially when it comes to situations like this. That may change depending on the situation, but if somebody's ass is on the line, make sure it's not yours. Make sure it's their ass on the fucking line, because that's their fucking job. So the question is, who is the trustee and who is taking the responsibility for the trust activities? The attorney, truster. The attorney is also the trustor. He is putting the trust corpus into the trust. That is the charge. It is a debt liability on the public side. Everything is commercial. And a credit asset on the private side. Credit asset on the private side, which means that you can go ahead when you figure all this shit out. I'm not going to tell you how to do it here, or probably ever, but you figure out how to do, how to fucking discount this, because you are the original issuer of the bond, right? Because it's made in your name. So we have always presumed a charge is a bad thing. It is only bad if the man is found in contempt of the process, or of the attorney, or of the judge. All right. So, or of a number of other possibilities. It is very easy to go into contempt. If you don't agree to take the responsibility, you will be in contempt of our presumed fiduciary duty. Creditors do not go into contempt, right? So beneficiary. The beneficiary is the state of whoever's charging you. I don't see how they're the fucking beneficiary, but which is also the plaintiff in the case, right? So it is the person that stands to gain from the charges, the trust corpus, but it only has the equitable interest in the trust corpus. That way, the beneficiary is not held. What the fuck? Or held. That way, the beneficiary is not held responsible for bringing a claim without a bond, evidence of a debt. The attorney does it instead. The beneficiary has to hold on to its creditor position and can't if it brings unfounded claims. The plaintiff seldom signs the complaint. The attorney's signature is usually the one on it. So, and then so one of the big things is that whoever brings the charge has to bring the remedy. Right? So if you choose not to partake in their fucking bullshit, you have to ask them, well, what are my options for remedy here, right? Because they can't just start throwing shit at you without you having a fucking way out too. So they're not always gonna fucking tell you, right? Otherwise that's gonna be a fucking dictatorship. And that's not what the fuck that we live in. So here it says the beneficiary is the state of. Which is also the plaintiff in the case. It is the person that stands to gain from the charges. So the trustee. This is the trust position that carries all the liability. The trustee has a fiduciary duty to manage his trust property for the benefit of the state. If it does not, the trustee accepts the responsibility for the losses suffered by the beneficiary. The state, there is no appointed trustee. There is no presumption that there will be a trustee when it is needed. The attorney has the complaint served on the original trust with a name like the accused individual, the defendant trust. Someone has to represent the defendant. At this point, the only representative for the trust is its creator, the prosecuting attorney, which has made a commitment to the beneficiary. Once the charge is signed by the attorney and delivered to someone who might volunteer to be the trustee, the attorney does not even have the option of withdrawing the charge without the defendant's agreement, the rule of the court. Since the complaint was delivered into your hands, the presumed trustee and surety, you have to agree to the withdrawal of the charges before they can be withdrawn, right? So this is why they always want you to put in a motion. So that way it doesn't seem like when they know that they're losing, right? They want you to still put in a motion to ask them to fucking drop the charges or fucking whatever. Even though they could just drop it, but they need you to fucking agree to it without you knowing that you're making them do it. You know what I mean? So that's what it is. So here we have, as soon as you hire a good attorney or decide to defend the trust yourself, the liability has moved from the prosecuting attorney to you. The fact that you are defending all by itself is a dishonor. Anything other than all-out acceptance is a dishonor. Your dishonor is what gives the prosecuting attorney the energy to bond the case. All cases have to be bonded. So, I mean, you can go ahead and move forward to, you know, find out if it's bonded and shit like that too with the clerk's office before you start entertaining their bullshit to begin with, right? Whoever bonds the case is the creditor. And so if it's not bonded, then you fucking bond that shit. Right, so whoever is in dishonor is the debtor. They need you to dishonor the process, the attorneys or the judge, to have the standard script result, the standard outcome. If you fail to immediately go into dishonor, there will be plenty of opportunities in the script for you to carry out the plot to get you into dishonor, right? And so everything that they're gonna do is gonna be a fucking play on words. A linguistic fucking gymnastic contest is essentially what these fucking people are going to be doing to you. So the way that I would deal with this shit is by not speaking to these fucking people and having them put everything that they all of their presentments are not going to be verbal. They're going to be in the form of an affidavit signed under the penalty of perjury, and they're all going to be signed. Right? You don't even have to entertain some shit like that from these people just throwing fucking words out of their corny ass mouths. You don't have to entertain that shit at all. So you can plead not guilty, testify, defend, call witnesses, question witnesses, file motions, file a countersuit, answer questions, or not respond at all. Just to name a few ways to volunteer to be the trustee and to be in honor. Your voluntary dishonor will authorize the use of your credit to bond the case. Since you did not voluntarily bond the case, you are in dishonor. Right? So you always want to find out if the case is bonded. Me personally, I would go ahead and bring my 1099 forms in there, my 1099A, 1099C, and probably even the OID, and maybe even a 1040, right? Because you're gonna go ahead and want to claim that. You're gonna need all their information. You're gonna want to get the EIN, TIN of each of these individuals, because the bond the judge is supposedly the judge. They're really just a clerk magistrate. So you're gonna need their fucking TIN, EIN, their bonding information, as well as the prosecuting attorney. You're gonna need all of their information from their corporation, and then you're gonna find out if that fake ass lawyer or whoever the fuck's claiming to represent you actually has a bond as well too, because you're gonna have to hold them all liable. And since they're creating debt out of thin air, because essentially all this shit is just a commercial charge, you're gonna go ahead and want to claim this shit on your taxes, and they're gonna be paying the fucking taxes on that. So, surety. Since the standard script will be used for the court event, it will likely be the man who has volunteered to be the trustee for the accused trust will defend the trust. That will guarantee the standard outcome. The defendant will be found guilty and the trust corpus will be liquidated enough to pay the judgment debt. If the event involves criminal charges, the man's body will be jailed so the state can revenue the man's credit from the private into the public. This is what keeps the public machine running, revenue. So the man will be the surety for the judgment debtor once the trust is found guilty. So the trust is found guilty. See that? It isn't you. It can't be you, because they only have the jurisdiction over their creations. And since they created the trust to begin with initially when you were a fucking child that you somehow became a surety for, they only have the jurisdiction over that piece of paper. It isn't your physical body. It isn't your child's physical body that they're ever speaking about if you ever go to court and child custody shit or whatever the fuck it is. They only have jurisdiction over the paper. So stop giving them your fucking body and stop giving your children's body to these fucking assholes that they don't have the jurisdiction over. They only have power over the paper. That's it. So, let's see what we got here. Alright, so let's go to the next slide. The plaintiff, the state beneficiary, is the plaintiff and presumed creditor, as long as the man plays by the standard script. Defendant, the prosecuting attorney needs to have a volunteer to defend the trust, or he will be stuck representing the accused trust himself. He is the defendant, but does not plan on holding the position very long. Right? They're going to try to pass the ball, pass the buck. So with the help of the judge and the defense attorney, the prosecuting attorney will be able to pass the liability onto the trust and its representative and surety, you. So, but you have to go into dishonor for this to happen. All charges, arguments, and testimony is dangerous in the public court. It is. So remember, it is not your court. They can only see fiction. So if you're testifying, you are recognized as the fiction, as you are a piece of paper. That's why you want to go in as the authorized representative, speaking on behalf of, right? But it is you are talking to him. He presumes you are the trustee for the truster. In the capacity he can talk to you. He is expecting you to breach your fiduciary duties by going into dishonor. Then they win, you lose. You want a win-win situation, right? Essentially. So be careful, even with the copyright. If you can bring the copyright into the case without testifying through third-party witnesses, you may be able to stave off a demand for trust property. If you have already given the right to use the now copywritten name to a corporation, you cannot revoke it and that authorization after the fact. You may have done that by applying for a loan. You gave them the use of the name on the application. You can give the use of the name on a driver's license application. You are the one who tells what name to put on the license. You can't come back later and charge them for using the name previously gave to them. If there is no driver's license application, you may be able to give notice to the copyright to the officer and then enforce the copyright violation because he had notice of your restrictions to use the name. Even if the car is registered with the state, you may be able to use the copyright in this action. If you know how and do not dishonor your own claim by being the private owner of the name. So essentially what they're saying is that you want to try to find a way to file the fucking copyright without fucking testifying to the fact. So so keep in mind that if at any point this shit ever gets out of hand, right? Because the government is in place for your benefit, right? It starts to get too fucking stupid in there. Whatever the fuck, these people are playing too many games. Scroll down, look at the video of the affidavit of rescission, right? Affidavit of rescission. And go ahead and file that. And what you're going to do at that point, or what I would do, is cancel all fucking contracts with them at all, ever, from the fucking beginning of time to right the fuck now, and walk the fuck out of it. You know what I'm saying? You really don't have to entertain their fucking bullshit, especially if they start getting fucking retarded in there, trying to play stupid ass games and shit like that, right? So, you play up until you feel like maybe you're not getting the upper hand, because you should always have it. And if that gets to be the case, hit the fucking eject button. Always keep that shit in your back pocket. Hit them with the fucking affidavit of fucking rescission and tell them to suck a dick. You know what I'm saying? And leave. Really that simple. So just make sure you do it in time before you go into this dishonor. Because obviously you don't want to argue with them, none of that shit. So definitely want to have this all down pat before you even go in there. A lot of people go in there thinking they know what they're talking about, end up in jail. If you're scared of jail, get a fucking lawyer. If you're scared of jail, go grab a lawyer, bro. So it is a game of chess. Stop playing checkers with these fucking assholes. That's what I got for you for now. Until we meet again.